Because if there is an iota of doubt based on which the NHRC gives order, please remember that can be challenged before the High Courts. There are many state governments who are challenging the orders of the National Human Rights Commission. We ourselves have almost filed about 70 odd cases against the NHRC, not agreeing with the procedure as well as the final order before the Delhi High Court. So please remember, it is also responsibility of the, when NHRC gives an order, what you know as the truth, if you cannot establish with the evidence, it's very, very difficult. And of course, the scrutiny will not be as hard as in the judiciary. They can take the course to probability and give a sympathetic judgment. But please remember, even in that case, they require some evidence. Otherwise, it cannot go in your favor, because no members of the NHRC wants their order to be challenged before the High Court. Government is a bad defender of itself in the court. NHRC is worse than that. NHRC registers about 100,000 complaints per year. We file possibly about 300 to 350 complaints a year. Do we represent somebody who can speak about the NHRC? Surely not. Because the type of complaints which we file are on particular issues. We have certain kind of expertise. So the complaints themselves, when they are filed before the National Human Rights Commission, they actually vary from NGOs to NGOs, organizations to organizations. And how many organizations present here actually approach National Human Rights Commission systematically to form a substantial portion of the 100,000 complaints to make an opinion of the NHRC? No, it is very, very difficult. So it shows that the huge number of victims across the country who are approaching the National Human Rights Commission without the support of the NGOs on their own. So there are citizenry of this country who are approaching the National Human Rights Commission. So what we have is essentially a perception. It is not necessarily the truth about the complaints handling, because each complaint depends on so many factors, as each case depends when you are adjudicating before the judiciary. Before I make this final comment, there are issues which I want to highlight for the distinguished members of the tribunal. There are issues which are beyond the competence of the NHRC. You cannot blame NHRC for everything. You cannot blame NHRC for the appointment. You cannot blame the NHRC for the composition, for the selection, powers, functions, finance, legislative measures. At the end of the day, it's the responsibility of the Government of India. NHRC cannot invite Suhas Chakma to be a member of the Commission because they don't have the mandate. So there have to be some specific recommendations which relates to the Parliament, the executive, and some recommendations.
I think we all know it's the government that is created. That doesn't mean NHRC can't be blamed.
Yes, sir. I think once I finish, you can come back to that. So there are distinctions between.
We can't keep NHRC the way it is functioning.
So there are two ways to look at it. One of the ways to look at it is the powers of the NHRC, which are legislative matters, and the issues which fall within the mandate of the NHRC. Complaint handling is something which can be tackled by the NHRC because they do not require any support from legislatures. As far as the complaint handling is concerned, when the NHRC started, there were no specific dates when the next case will come up. We have cases which have taken about 5 years to be shelved, to be taken out from the files. At least in the last 1 year, with the help of the current register, they have introduced one system that when this current complaint is heard today, the next date of the hearing should be put in the file. And this was even missing in the NHRC because there were no hearings. There were complaints which were not considered even once for 5 years. The second problem with the NHRC is that when a complaint is filed, both the complainant and the estates are not given equal access to the documents. So when an NGO files or a victim files a complaint, it is immediately forwarded to the complainant, to the government. But when the state responds, those responses, NHRC exercises its discretion. And discretions could be arbitrary and abusive. So there are many cases which we ourselves file that we are not informed, and by the time we are informed, many of the important proceedings are over, so it is not possible for us to make appropriate intervention. And on these issues also we have gone to Delhi High Court, saying that both the respondent and the complainant should be given equal time. And in terms of the time, NGOs are hardly given 4 weeks, and the states are usually given at least 12 weeks to 16 weeks, or sometimes more than that. So unless and until I think there is equal time and equal opportunity in terms of dealing with the complaints, it becomes very discriminatory because the NGOs, the victims themselves are not able to effectively contribute. And one of the key problems at the moment, the proceedings of the NHRC, all the proceedings of the NHRC are not informed to the complainant. So one of the recommendations which we had before the NHRC and still have been implemented, that the way the daily orders of the high courts or the lower courts are uploaded, why can't the NHRC maintain those orders in their websites? This has not been done. And it creates a serious problem because you have to follow up. If you are following up 2,000 cases, every month almost you are examining 2,000 complaints in the website of the NHRC to know what is the status. Because if you cannot examine them, then you cannot make effective summations at that point of time. So there are problems with the suo motu actions. With suo motu actions, the NHRC has not developed any guidelines. So because of the lack of guidelines in what matters the NHRC should intervene suo motu, it becomes very arbitrary and it's very unclear as to in some cases where they intervene and where they do not intervene. So I think on all these issues which I have mentioned, I think NHRC can improve beyond the Paris principles. Please remember, when the Paris principles were adopted in 1992, they were based on one-man ombudsman's experience in Europe. The Paris principles do not comply with the basic standards we espouse today. And because of the Paris principles, you have even the policy institutes, like the Danish Institute for Human Rights, as a full member of the ICC without actually the power to adjudicate in individual cases. So the final recommendations which I wanted to make is that it's very clear. It's a sub judice body. As much power given or the procedures followed in the judicial proceedings, the National Human Rights Commission should follow. If they follow that, I think the complaint handlings could improve substantially. Thank you.
I think you're forgetting one small aspect, that there is a mission in the commission. There is a word, if you have commission, there's a mission in it. So I think, don't you think there is a need to distinguish between a commission and a trial court? If you go into taking records and reports and cross-checking and counter-cross-checking, I think it will take years.
See, when a police submits report, there are many discrepancies. And unless the NGO is given the opportunity to scrutinize and give comments, then how can NHRC make effective adjudication? When NHRC visited Manipur this year, 2/3 of the cases were filed by us. But at least 99% of the cases, NHRC had not informed us of anything. So how could we go and participate in a proceeding in Manipur, in a hearing, when we do not even have the basic papers? So the basic papers, whether it's by the state commissions or the NHRC, they have to be provided for the sake of justice. Otherwise what happens is NHRC only hears the story of the police. The state commission only hears the story of the police. Both the state commissions and the NHRC must give access to equal documentation for me to make an assessment. Even if it's delays. Because as I said, 30-odd cases of extrajudicial killings in Manipur, we have not been informed in a single case, and they invited us to go to Manipur. I wrote a protest letter saying I cannot come because I do not even have the papers. So that is why it's essential.
But in the complaint itself, part of the evidence would be there. No?
Yes, but then my complaints are disputed by the state. State submits its own evidence, post-mortem reports. Post-mortem report has been distorted. One particular portion has been taken up. The important portion has not been taken up. So it's for me in a subsequent complaint to examine all the evidence and say this is where the state lies. And in most of the cases where we have won about 4 crores compensations in the last 5 years, it is because of the flaws in the state reports. And if you leave it to the NHRC staff, they may not necessarily be able to pick up what we as NGOs and victims are able to pick up. So that is why we need access to all the documentation. If the commission members continue to exercise discretion You are actually denying both the complainants and the victims, and in that case you should not register any complaint.
Thank you. समय के अभाव के कारण हम इसका संक्षिप्त में समरी अभी नहीं बता पाएंगे. Our last speaker for this first session today is Mr. Arvind Narayan. Arvind Narayan will talk on sexual orientation, gender identity, and the attitude of NHRC towards this issue.
Members of the jury, I will be addressing the issue of the rights of the lesbian, gay, bisexual, and transgender community and their engagement with the National Human Rights Commission. I think the moment is very appropriate because we are coming just 2 days after the judgment of the Supreme Court in Suresh Kumar Kaushal's case, where the Supreme Court has said that the lesbian, gay, bisexual, transgender community is a minuscule community and there are less than 200 reported cases, orders or decisions of the use of 377 against this community, and hence it is not necessary to judge the constitutional validity of section 377. So coming from that decision, the question in my mind really is, what could the National Human Rights Commission have done? What has the National Human Rights Commission done, and where has it really failed? Has the community, the lesbian, gay, bisexual, transgender community, engaged with the National Human Rights Commission? The answer is the community has attempted to engage with the National Human Rights Commission. In 2001, a complaint was filed before the National Human Rights Commission, and the substance of the complaint was basically the narrative of a person who was subjected to aversion therapy or shock therapy by doctors in India's premier medical institute, the All India Medical Institute, AIMS, where the person was given aversion therapy to convert him from homosexual to heterosexual. He filed the complaint before the National Human Rights Commission, and the response of the National Human Rights Commission was to dismiss the complaint. We had a chance to meet with, I think the person whose name has been taken very, very often, the respected Dr. J.S. Verma, and ask him, as we were students at the time in National Law School, ask him as to why the complaint was rejected. And his response is twofold. Firstly, he said, anyway, section 377 is no offence as far as the law is concerned. So why are you complaining? His second response was to say, all this is the result of a couple of NGOs with no grassroots support. So what's the big issue anyway? That was the response which we got, off the record as it were. And I want to take that to the mandate of the National Human Rights Commission. We talked a lot about the complaints mechanism, but I think the National Human Rights Commission has an even more important role to play. The role the National Human Rights Commission should play is really the realm of ideas. In spreading, as the language being used was spread the idea of the human rights culture, as it were. If you look at the mandate of the National Human Rights Commission under section 12F, G, H and I of the Protection of Human Rights Act, the power to study treaties and other international instruments, to undertake and promote research in the field of human rights, spread human rights literacy. These, I think, are very, very, very important functions, merely for the fact that you need to understand that human rights is a very broad category. Understand human rights in terms of the particular mandate or the way human rights law is really developed.